Good morning, everyone. This meeting is called to order. Mr. Trowman, has anyone signed up for public comment? Thank you, Mr. Trowman. Good morning, Mr. Treadwell.
Good
We have
morning,
no
sir.
cases to reconsider on agenda item 3. Is that correct?
That is correct. There are no cases under agenda item 3.
Ms. Turner gets faster and faster at getting up to the podium. I didn't even have time to ask what her walk-up music was today. But we're going to look at tax liability cases under agenda item 4. I think we have 2 tax cases on docket 25.
Yes, sir. Sorry, 2 tax cases. The first one is TD 23-006-0223, Commissioner Demerson,
I agree with staff recommendation.
Commissioner Trevino,
I agree with staff recommendations.
and Chairman Daniel.
I agree with staff recommendation. Agree with staff recommendation.
The next case is TD 23-007-0822, Commissioner Demerson,
I agree with staff recommendation.
Commissioner Trevino,
I agree with staff's recommendations.
and Chairman Daniel.
Agree with staff recommendation.
Okay, thank you.
All right, fair housing cases, none under agenda item 5.
That's correct.
All right, under agenda item 6, we have no wage claim cases on docket 25 pulled for additional discussion.
There are no wage cases claims pulled for discussion on docket 25. You should have received the wage claim short form dissent list for docket 25.
I move we accept staff recommendations on the remaining wage claim cases on docket 25.
Now, I second the chairman's motion, except for the cases on which I'm dissenting is reflected in the wage claim short form dissent list for docket 25.
I concur with Chairman's motion, except for those cases on which I am dissenting as reflected on wage claim short form dissent list for docket 25.
Motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 25. Please proceed when you're ready.
Case number 277-3610, Commissioner Demerson.
The commission should grant a rehearing in this case. It is unclear whether the claimant was in fact unemployed during the time she filed her claim for benefits. The claimant's pay stub that coincides with the week that she filed her claim covers a 2-week period. The pay stub does not indicate how many hours the claimant worked in each of the 2 weeks. As such, we should rehear this case to question the parties specifically about how many hours the claimant worked during the week that she filed her claim. Such testimony would clarify whether the claimant was unemployed during the week she filed her claim. Rehear.
The decision is not correct. The evidence clearly established that the claimant's initial claim was valid as her hours had been reduced due to the pandemic. The evidence further established that the claimant was partially unemployed at the time the claim was filed, as her wages were less than 125% of her established weekly benefit amount following the reduction in hours. Therefore, the initial claim dated May 17, 2020 was a valid claim for benefits under section 201.091 of the Act. Reverse the AT, valid initial claim.
Rehear.
The case will be reheard.
Case number 307-8639, Commissioner Demerson.
We should remand this case to the appeal tribunal. The timeliness of the employer's petition to reopen and whether the employer had good cause for missing the first AT hearing are issues in this case. However, the AT failed to adequately develop the record concerning these issues. The lack of proper development of the record arguably denies the employer due process. I would also note that the first hearing was scheduled more than a year after the employer's appeal. Accordingly, we should remand this case to the appeal tribunal to further develop the record on the issues of timeliness of petition to reopen and good cause for missing the AT1.
The AT decision should be modified. The employer's petition to reopen was late, and there is no good cause exception to the timeliness rules. The employer was responsible for updating their address with the commission, which they failed to do so. Modify the AT decision, set aside AT2 decision, late petition to reopen, late AT appeal, chargeback.
Remand.
We will remand the case.
Case number 318-6546, Commissioner Trevino.
The decision is not supportable. The evidence clearly established that the claimant submitted his required work search log to the commission for the weeks ending 8/14/21 and 8/21/21. The claimant should not be punished with a disqualification and an overpayment just because he faxed the work search logs 1 day earlier than fine print of the work search notification instructed. This is not just the outcome for such a minor and harmless mistake. Reverse the AT, no disqualification for extended benefits, no overpayment.
The AT decision may not be supportable under the available facts. The claimant's initial ineligibility was open-ended based on a determination that he had failed to submit a work search log. As it turned out, the only problem was that he had submitted a work search log 1 day early. There's nothing in the record concerning why such an issue resulted in 4 additional weeks of ineligibility beyond the 1 week in question. Accordingly, I believe we should have this case resubmitted on the issue of whether the ineligibility beginning August 8th, 2021 should have been treated as a continuing ineligibility case and closed after 1 week.
Reverse the AT, claimant is eligible for extended benefits, no overpayment.
Short form dissent.
I have your short form dissent, Commissioner Dimerson.
Case number 3339360, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant was discharged for submitting a false doctor's note related to an absence. The employer contacted the medical office to check on the authenticity of the note and was informed that the note was not legitimate. In the absence of testimony from the claimant, the employer has met its burden of proving that the claimant was discharged for misconduct connected with work. We should reverse the AT decision. Misconduct, no chargeback, adequate employer response.
The AT decision is correct. The claimant denies that she falsified the medical documentation submitted to her employer. The employer failed to provide sufficient evidence to support its claim in either hearing conducted, and thus failed to meet its burden to establish misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, sir.
I have your short form dissent, Commissioner Trevino.
Case number 3374195, Commissioner Trevino.
The AT decision is not supportable. The claimant testified under oath that when he was hired, he was told his hours would be at least 32 hours per week. The employer failed to provide sufficient evidence to overcome the claimant's testimony. He worked 32 hours per week until he went on an approved vacation. When he returned, his hours were reduced significantly. The claimant complained to his supervisor many times about his hours, but his hours were never consistently 32 hours per week. The claimant was laid off due to lack of work when the employer failed to schedule him for any hours during his last week. Reverse the AT, no misconduct, void reimbursement billing rule.
We should modify the appeal tribunal decision. Although the claimant alleged that a reduction in work hours led him to quit, the record shows that the claimant did not adequately communicate his concerns about his work hours or allow the employer an opportunity to remedy his needs. Since the claimant quit when continued work was available, the claimant's separation was a voluntary quit without work-connected good cause. As such, we should modify the appeal tribunal decision, voluntary leaving, void the reimbursement ruling.
Reverse the AT, no misconduct, void reimbursement ruling.
A short form dissent.
I have your short form dissent, Commissioner Dimerson.
Case number 3375324, Commissioner Dimerson.
The commission should rehear this case. In the employer's appeal to the commission, they allege that they did not file a timely appeal due to misinformation received from an agency representative. Since the employer's additional evidence is critical to determine whether the appeal was timely, we should conduct a rehearing to question the employer and obtain additional information about the timeliness of the employer's appeal. Rehear.
The employer's CA appeal was late. The employer presented insufficient evidence to establish that they received misinformation from the commission representative regarding filing an appeal during the appeal timeframe. Dismiss the employer's CA appeal as late. Employer's reimbursement account remains billed.
Rehear.
The case will be reheard.
Case number 3392844, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant quit based on negative comments he received as a part of his performance review. Although the employer advised the claimant of their intent to investigate the contents of his performance review, the claimant quit prior to allowing the employer an opportunity to investigate or address his needs. Since the record suggests that the claimant had continued available work, but thereafter quit prior to allowing the employer an opportunity to remedy his concerns, the claimant's separation was a voluntary quit without work-connected good cause. As such, we should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The AT decision is correct. The claimant voiced his concern to HR regarding his supervisors insulting him because of his health condition and not permitting the claimant to walk during his breaks or go to doctor's appointments. The actions of the claimant's supervisor made working conditions intolerable, and the HR's actions did not adequately address the claimant's reasonable complaints, giving him good cause to quit. Affirm the AT, no voluntary leaving, chargeback.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response.
Short form dissent, sir.
I have your short form dissent, Commissioner Trevino.
Case number 3393991, Commissioner Trevino.
The decision is not correct. The employer discharged the claimant for his inability to meet its quarterly sales quota, while the employer's HR manager vaguely indicated that the claimant's performance was adequate during his first 7 months on the job until the end of 2021. The evidence established that the employer sold parts of its company off in December 2021, which substantially reduced sales revenue and caused the entire sales team to struggle to meet their quotas for the following quarter. This downturn in sales revenue directly coincided with the claimant's inability to meet the employer's sales goals. This is not misconduct. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant was able to adequately perform for the employer for several months before his performance declined. As a result, the claimant was put on a PIP. The claimant was told he would be terminated if he did not meet his goals. In addition, the employer stated that the goals were attainable. When it is clear that the claimant was not going to be able to attain the goals of the PIP, he was terminated. As such, the claimant's failure to perform to the employer's standards constituted work-connected misconduct. Should therefore affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent, sir.
I have your short form dissent, Commissioner Trevino.
Case number 3425939, Commissioner Trevino.
The AT decision is not correct. The claimant was able to work since filing her claim and merely pushed the wrong button while making her payment request. The claimant had a dentist appointment and was otherwise able to work. Reverse the AT, able to work beginning October 9th, 2022. Alternatively, the claimant also testified that she was able to work as of October 23rd, 2022, and the ineligibility beginning October 9th, 2023 should be closed effective October 22nd, 2022.
The appeal tribunal decision should be affirmed. The claimant provided a fact-finding statement stating that she has medical restrictions that prevent her from working and that she understood restrictions on her ability to work could prevent her from receiving benefits. While the claimant's testimony conflicts with her fact-finding statement, the appeal tribunal was in the best position to gauge the credibility of the claimant in this case, and its ruling should be left undisturbed. She therefore affirmed the AT decision, ability not eligible, beginning October 9th, 2022.
Affirm the AT, claimant not able to work beginning October 9, 2022.
Short form dissent, sir.
I have your short form dissent, Commissioner Trevino. This concludes consideration of UI cases pulled for additional discussion on docket 25. You should have received the UI short form dissent list for docket 25.
I'll move we accept staff recommendations on the remaining UI cases on docket 25, except for the case which I am dissenting is reflected on the UI short form dissent list for docket 25.
Second, the chairman's motion, except for the cases on which I'm dissenting, is reflected in the UI short form dissent list for docket 25.
And I concur with Chairman's motion, except for those cases on which I am dissenting as reflected on UI short form dissent list for docket 25.
Motion passes with the exception of. This brings us to the end of agenda items 3 through 7. We'll take a short recess. All right, we're back. It's agenda item 9, local workforce development board nominees.
Good morning, Chairman, Commissioners, and Mr. Cerna. For the record, Cherie Dudley with Workforce Development. Today, for your consideration, we have Workforce Board nominations for Alamo, Heart of Texas, Greater Dallas, Rural Capital Area, and Southeast Texas. Staff recommends approval on the presented nominees, and I'm here to answer questions you may have.
Comments or questions?
None here.
None here.
Is there a motion?
Mr. Chairman, I move that we approve the local workforce development board member nominees presented today for the following offices: Workforce Solutions, Alamo, the Heart of Texas, Greater Dallas, Rural Capital Area, and Southeast Texas.
I second the motion.
It's been moved and seconded. Vote unanimous. Thank you.
Thank you.
I don't see a legislative report lurking in the back. Mr. Cernan, Executive Director's report.
Yes, sir. Very quickly, last commission meeting, you had asked staff to go back and look at ways to improve and shorten the amount of time it takes us to develop rules. Staff has done that. We'd like to provide a brief overview. If there are no questions, we're going to proceed after the overview. If there are no questions or anybody needs further information, if any of you all do, then we will certainly brief the offices and come back and finalize them. But so with that, I'm going to ask Reed O'Brien to come up and kind of lay things out for us.
All right, good morning, Chairman, Commissioners, and Mr. Cerna. For the record, I'm Reed O'Brien, Office of General Counsel. As Mr. Cerna just stated, as requested, staff have reviewed the agency's rulemaking process to identify any improvements that we could make to improve that process and make it more efficient. And staff has determined that the most significant and immediate improvements to optimize efficiency would be to remove the policy concept phase from our rulemaking process. State statute requires state agencies to publish their proposed rules and adopted rules in the Texas Register, but the policy concept is something that TWC does in addition to those requirements. The policy concept is like a mini discussion paper that staff prepares and presents to seek the commission's approval to move forward with developing proposed rules. And staff has determined that while it has its merits, the policy concept phase is redundant and time consuming for staff, management, and the commission, and it adds 3 months to our rulemaking process. This additional time becomes especially critical when we need to implement legislation complete rulemaking before the next legislative session begins or meet other necessary deadlines. Removing the policy concept phase would immediately cut a standard rulemaking timeline from about 10 or 11 months down to approximately 7 months. And we have enough flexibility built into the process so that we could reasonably expect several rules to move from proposal to adoption in 6 months or even less. If the policy concept phase is eliminated, staff will continue to keep the commission informed about upcoming rule projects through the regular briefing process. And please note that the elimination of the policy concept phase will not affect or reduce the comment period during which the public and boards can offer comment on proposed rule changes. That concludes my remarks. I'm available for any questions.
Any comments or questions?
Sure, I think it's always good when we're finding efficiencies, and I encourage the team to continue to do so. Cutting 3 months off is amazing, and I think we're going to see some real good progress there.
Yes, sir. Thank you.
Yep, no comments. Thank you.
All right, thank you.
Mr. Chairman, but Reed, though, I've not seen Reed in quite some time. So
It's been a while. I've been
Yes.
I feel like he must have at some point historically spoken for the committee. We need to probably think about some sort of rulemaking of our own, like on like a 12-month period or an 18-month period. We'll work on that.
All right, thank you.
We have nothing else for the commission. So with that, I'll close.
All right, is there any other order of business come before the commission?
Mr. Chairman, I think after this commission meeting, we're going to have intern photos. And so I know there may be a number of interns in the audience, and if they are there, I'd like to kind of ask them to stand if that's okay.
That group multiplies every week.
That's awesome.
Yeah,
So,
that's good stuff.
good stuff.
It's like half the crowd today was the intern.
I wasn't having to come up to the front to the mic and introduce themselves, but I'll forego
Well, that'll
that.
give us something to do next week.
That's right. So,
Yeah, I just want to acknowledge Rebecca Westney. She's going to be on my team now as a attorney. So she helped out before, but I'm glad that she's back. So just wanted to welcome Rebecca.
All right, is there a motion to adjourn?
so moved.
I second that
Been
motion.
moved and seconded that we adjourn, and we are adjourned.
All right.